And this matter is a continuation of an evidentiary hearing that we commenced a while ago, but did not complete. And at this time, I invite counsel to place your appearances on the record. We can begin the prosecutor's office.
Thank you, Your Honor. Scott Vander Colt for the people.
Thank you.
And Attorney Evan Hebert on behalf of the defendant. Or I
Very
should say the
Respondent.
Thank you.
Very good. All right. And with that, my understanding is Mr. Vander Colt has some additional questions for the petitioner at this time. Mr. Hebert lodged an objection to recalling petitioner during a pretrial meeting with the court, but I have overruled that. Anything additional to place on the record regarding that objection, Mr. Hebert?
If we're gonna call Miss Jackson, I would like to ask some follow-up questions of Miss Cooley as well. I think that's only fair.
Very well. Well, let's see if what Miss Jackson testifies to, and if Miss Cooley needs to be recalled. Certainly, I can entertain that at the appropriate time. So, at this time, I will swear in the petitioner.
Respondent, Your Honor.
Pardon me?
Respondent? Ms.
Oh,
Jackson?
it's the respondent who were okay. Very well. Then Miss Jackson, if you would raise your right hand. Do you solemnly swear or affirm that your testimony today will be the truth and nothing but the truth?
Yes, Your Honor.
Very good. You may proceed, Mr. Vander Colt. And so I guess this is the continuation of cross-examination.
Thank you. Ms. Jackson, in the past 10 years, have you been convicted of any crimes of theft or dishonesty?
Your Honor, I'm gonna object. I understand this isn't a criminal proceeding, but a 404B notice wasn't filed.
This isn't under 404B. This is under 609.
Well, I don't think that it's relevant. I have not been provided with any criminal history that I could use prior to today's hearing. And frankly, I think it's unduly prejudicial.
Well, Your Honor, Rule 609 says it's not unduly prejudicial, and it says the evidence is admissible if during cross-examination it's been elicited from the witness, and she can either tell the truth, or deny that. But this is Mr. Hebert's own client. It's not the people's job to do a background investigation at the behest of the defense. The defense's job to know their client's history, and this is relevant under 609 A2.
And my recollection is, Mr. Hebert, you put on at least one witness that testified to your client's reputation for truthfulness in the previous hearing. Is that right?
Well, Nasir was a fact witness. He testified to being there. He was asked questions by Mr. Vander Colt about their relationship, but I don't think I opened the door to any of this by asking for him to give reputation or opinion evidence about her truthfulness. I mean, I think, Your Honor, you can give the evidence appropriate weight. I don't think that, it's something that is going to be make or break in this situation. But I guess the other objection I have to it is that we could have done this last time. And I don't see why we're reopening the cross-examination when there was a full and fair opportunity to present this at the first hearing.
Understood, and I already stated that objection's preserved for the record to reopening cross-examination. However, I have allowed it in this case, and therefore I'll overrule the objection and allow the response to the question. Ms. Jackson, you may proceed.
Yes, I've been in some trouble in my past
Okay, what was the nature of that trouble?
for retail.
That was felony retail fraud, wasn't it?
It was.
Okay, thank you. I have no other questions.
Mr. Hebert, any redirect?
Thank you. Ms. Jackson, you've provided some testimony in this case already. Do you recall testifying at the last hearing?
Yes.
You testified under oath during that hearing, correct?
Mm-hmm.
Did you understand the nature of the oath that you took?
Yes.
And what is that to you?
To be completely honest.
Have you ever testified under oath before?
Yes.
Okay. And have you ever been convicted of falsely testifying under oath?
Absolutely not.
The retail fraud situation that you were just asked about by Mr. Vander Colt, in that case, did you testify?
In that case, I pled guilty over several years ago, if I may state.
And what year was it? Do you recall?
2016.
So almost, about 8 or 9 years ago.
Yes,
And you said you pled guilty in that case?
I did.
And is that because you were telling the truth that you were guilty?
Yes, correct.
Okay. And you told the truth in this hearing that we had in this matter.
Absolutely.
And when it comes to Miss Cooley, do you have concerns about or let me rephrase that. Why do you think that you're here today?
Objection, Your Honor. How is this relevant to her retail fraud conviction? This was a matter for direct several weeks ago. This is way beyond the scope of cross.
I feel like we just need an opportunity to kind of refresh our memories about some of this stuff. If we don't want to get into it, Your Honor, I know you can get a transcript of what she said, but I feel we
Counsel
really wanna
objected
get
to this in the first place. Now he wants to open up everything. He was ready for arguments, and now he wants to reopen it. So I would object on relevance at this point.
I mean, my objection was overruled, so.
Yeah, since I allowed, we'll go under the, what's good for the goose is good for the gander rule, and I'll allow the question. You may proceed.
Okay. Why do you think Miss Cooley has brought these allegations against you, Miss Jackson?
Because me and Mr. Cooley have been in a relationship, and from my perspective, she is very upset and angry about the decision that was made, and pretty much, would like to make my life as inconvenient as possible due to the circumstances.
And did this case, do you recall testifying about attempting to have her served with some documents?
Yes.
And who was,
Objection. This has been asked and answered, Your Honor.
And I do vaguely recall this information, so we don't need to rehash all of that, Mr. Hebert.
all right, thank you. Then you know what, Your Honor, I have nothing further. I appreciate it.
Very good. Mr. Vander Colt, any additional?
No, Your Honor.
Very good. Then you may step down. Ms. Jackson, Mr. Hebert, do you wish to recall Ms. Cooley at this time?
Yes, Your Honor.
Ms. Cooley, would you please raise your right hand? Do you solemnly swear or affirm that your testimony today will be the truth and nothing but the truth?
I do.
Okay, you may proceed, Mr. Hebert, with additional cross.
Thank you, Your Honor. Ms. Cooley, you had indicated for the court that there were other witnesses to the events that you testified last time that we were in court. Do you recall that testimony that you gave?
Yes.
And you indicated that there were 2 other people who observed this situation.
I said it was one other person that observed the situation.
Okay, so who is that other person that, based on your recollection of your prior testimony?
I said that was my daughter's friend that was at my home.
Okay, and so did you make efforts, or are you aware of efforts that were made to have that person testify?
Excuse me?
Are you aware of any efforts to have that person come to court today? So that
Yeah,
they-
she can't. She
Right.
talked to the prosecutor already, but like she wasn't on the actual porch when it happened. So he said, since she
No,
was
I'm
in the
not, I'm gonna
house.
object. Hold on, I'm gonna object. This is a fishing
Okay.
expedition. Council's
Okay.
trying to get into things that the witness has already testified to and cannot testify to the hearsay about what somebody else may or may not have seen.
Response, Mr. Hebert?
Your Honor, I'm asking her, she just said, no, she wasn't there and she didn't see it. Last time we were in court, she said, yeah, she was there and she saw it. And we adjourned so that this person could come to court and credibly testify about what she saw. And apparently what happened is this
No,
person
I'm gonna object about what apparently happened. This is not in evidence, Your Honor.
I'm not
The witness isn't
testifying.
here and we can't get into speculation about why or why not the witness may or may not be here. Miss
Miss Cooley,
Cooley was not the moving party, the people were, and the witness is not here. It would just be speculation on the part of Miss Cooley or hearsay as to why that witness isn't here.
well, so they were subpoenaed, so they should be here, and it shouldn't be up to the prosecution to say, oh, we found a new witness. This witness doesn't back up the petitioner's story, and so now we're not going to call them and bring them into court. I think that gives me
The people
every
are not a
reason.
witness, Your Honor.
And if they're unavailable, then she can testify about what they told about their prior statements, because
No,
they're
that would be hearsay, Your Honor.
What
Anything
about the
that happened
unavailability
procedurally-
exception to hearsay, Mr. Vander Colt?
Pardon?
What about the unavailability exception to hearsay? I mean, if they were subpoenaed, they're not here, ergo unavailable.
No, it's not that they're unavailable, Your Honor, and I'm not going to get into the reasons. If the defense wanted them, they could have subpoenaed them, but the people don't have them here, and it's not up to us to provide hearsay as to why that is.
I was told they were going to be here, so I had no reason to file a subpoena. I mean,
Yeah.
And that was the reason, after all, that we did continue the hearing. I'll allow.
I excuse the witness, Your Honor. If the court wants to grant the defense an adjournment so they can subpoena the witness and get around hearsay, that's fine. But everything else is pure speculation and hearsay at this point.
Your Honor, I don't want to adjourn this again. It's causing great distress for my client.
Okay, well, and what I think I'd like to do at this point is we'll continue. I'll allow you to argue the argument about the witness and why they may not be here in closing argument. However, I don't think there's any way we can get the story about the other witness from your client without eliciting here, or I'm sorry, from Miss Cooley without eliciting hearsay. So I will sustain the objection at this time. You may ask any additional questions that you have.
Ms. Cooley, just a moment ago, you said that nobody else was present when this
I
situation.
said another person was present. That's what I told you. It was another person was present at the time. Yes.
Okay. And who was that person?
Objection. This has
Her
been
name is
asked and answered,
Jashai.
Your Honor,
It don't
multiple times. Excuse me, Ms. Cooley. I'm lodging an objection. This has been asked and answered.
Okay, I don't remember the actual answer, so I'll allow the answer. You may ask it again, Mr. Hebert.
Who was that person, Ms. Cooley?
My daughter's friend. My daughter's friend was here. And
what-
she's not here now, so I'm here to speak of what happened to me. So you asked me what happened to me, and I'm telling you what happened to me.
What is this?
I don't need no witness. I am the witness.
What was this young lady's name?
I just told you, it's my daughter's friend.
And what is her name?
Her name is Jashia.
Okay. And where was Jashia when this took place?
When they pulled up to the house, Jashia was on the porch.
Okay. Did you just tell us a minute ago that she was inside the house before Mr. Vander Colt?
That's what I'm saying. She ended up coming inside the house. That's why he said that he didn't need her to testify, because she didn't actually see her. So that's why he did not want her to come. Because she was willing to come.
And isn't it true that Miss Jackson is in a relationship with your husband?
I'm not married anymore, and no, I don't know what they got going on at this point.
Are you aware that Miss Jackson was in a relationship at some point with the person who was at some point your husband?
I knew she was a person that he was conversating with, but in a relationship, I don't know. It was a gimmick to me. So if that's what you want to know.
What do you mean by gimmick?
It was a joke. That's what it was, a joke. So I cannot call that a relationship when you're two boosters stealing in the store. So no, that don't sound like a relationship to me. That sounds like a gimmick joke to me.
I have nothing further. Thank you.
All right. Any further questions, Mr. Vander Colt?
No, Your Honor.
All right, well, then I believe you may step down, Miss Cooley, and it is time for closing arguments, Mr. Vander Colt.
All right, thank you, Your Honor. Ms. Cooley testified very clearly that the respondent was at her residence. She had no reason to be there. And she was pepper sprayed as a result of the respondent being in violation of the court's order. Now, if the court will recall the testimony of Nasir Pettis, who the defense called, we have quite a conflict between what Nasir testified to and what the respondent testified to. When I asked about his relationship with the respondent, Mr. Pettis admitted that she helps him out with money. She tutors him. She drives him whenever he's needed, or when he has a car, she gives him gas money. She's provided food, helps him out with his studies. They've known each other for 4 years. But then when I asked Ms. Jackson about this, oh, it's a completely different story. No, money. No, maybe I helped him study one time. No, he doesn't stay here. You know, gas money, that's not an issue. Maybe I gave him a ride once. Complete minimization of their long-term relationship. But it's clear that Mr. Pettis was dependent upon the respondent and was going to say whatever she wanted to make her look like she was this great person, and the implication being, oh, she would never lie about this. But we know that she's willing to break the court's order. Obviously we have a contentious relationship here, or a contentious, I don't want to call it a relationship, but contentious existence between the two, which is why the PPO was taken out initially. So I'd ask the court to give Mr. Pettis's testimony the weight that it's due, which is next to nothing. And consider Ms. Cooley's clear, well thought out testimony, where she laid out the facts very clearly. For some reason, Ms. Jackson felt the need to serve Ms. Cooley with this and decided to have Mr. Pettis do that and go along, even though she was prohibited from being in her presence or within her eyesight. And there she was, right in violation of the court's order. And lastly, we've got Ms. Jackson's penchant for crimes of theft or dishonesty, not just retail fraud, not just shoplifting third, not retail fraud second, but felony retail fraud third. So while she did accept responsibility for that, she's got a conviction for a crime of theft and dishonesty. I'd ask that the court give it the weight that is due and find Ms. Jackson guilty of violating the court's order. Thank you.
All right, and Mr. Hebert.
Thank you, Your Honor. This case should be dismissed respectfully. And with regard to Mr. Pettis, Miss Jackson has someone backing up her story, who the court is not aware of any information that he has a prior conviction for even something as not related to truth as a retail fraud. Miss Cooley said she had witnesses. Those witnesses, for whatever reason, did not back up her story and are not here in court today and did not appear and have not provided any testimony under oath about this situation. It appears that the reason for that is because they told a different story than what Miss Cooley had previously testified to. And when we talk about Mr. Pettis, I understand that the prosecution wants to, besmirch him and his testimony, because his testimony was excellent. He said that he was the only one who went to serve those papers, that he got out of the car, that he did not have any contact directly with Miss Cooley, that he left the papers with another person at that location, and that Miss Jackson was not even present. And that this was done in order to ensure that there was compliance with the personal protection order and that Miss Jackson did not have any contact with Miss Cooley. Now, Miss Cooley was unable, although she stated and swore that there was another person with her, she was unable to identify that person as having been Mr. Pettis, despite the fact that there was some testimony that at least they were generally familiar with each other, and she had the opportunity to observe him not only allegedly on that date, but during the court hearing. And she was unable to say, yes, this is the person that I saw. And his testimony, I think, was very powerful. As far as the relationship between Mr. Pettis and Miss Jackson, I 100% disagree that Miss Jackson minimized or lied about the nature of their relationship. She said she helps him out when she can. And she admitted to doing things like taking him, getting gas for him, doing things for him, and helping him when she could. And so I don't think there's any reason to discredit his testimony. And as far as who's got the biggest motivation here to not tell the truth, we have Mr. Pettis, who's the only neutral party in this, who's not involved in this love triangle situation. You have Miss Cooley, who her ex-husband is now in a relationship with Miss Jackson. I think that provides an obvious motive, and I'm not going to beat on that horse, but there is always a concern that someone is going to use these proceedings and use this PPO process and weaponize it against someone who they don't like, or that they're motivated by revenge to try and hurt and potentially put that person in jail. And it is so serious that these type of situations take place all the time. And to allow that type of a penalty to be placed on Miss Jackson without some pretty strong evidence in just a he said, she said type of a situation is a very severe penalty to place, and potentially, it brings up a lot of issues as far as due process. There's limited process that we have in these circumstances, but I think it's still important to make a decision based on all of the evidence. Miss Cooley's testimony in this case was missing a lot of vital details that would have allowed the court to find that there was a violation. She could not describe Mr. Pettis. She could not describe what Miss Jackson was wearing. There was some testimony. She said that there was a camera on her front porch and that camera should have captured this incident, but she said it wasn't working. And there was not a really strong explanation or a good explanation by Miss Cooley of why that camera wasn't working. And in addition, she indicated for the court that she was pepper sprayed, but while they were too far apart for it to be reasonable for her to have experienced that type of an assault, she said she was injured, but there was no medical treatment sought. There was no evidence of any injury. There were no photographs. There was no medical records. There was no police report.
Oh my goodness.
And frankly, her conduct during the hearing, as far as being evasive in response to questioning, in trying to interrupt counsel when counsel was speaking, in trying to interrupt Miss Jackson and call her a liar when Miss Jackson was speaking, all indicates that this is a revenge power trip by Miss Cooley to try and lock up Miss Jackson because she's upset that Miss Jackson is in a relationship with her ex-husband. And the evidence, there's not a single piece of physical evidence or demonstrative evidence. It is a pure he said or she said type of a situation. And so we only have one independent witness who's not part of this love triangle. That person was Nasir. And despite Mr. Vander Colt's efforts to impeach him based on his relationship with Miss Jackson, I think his testimony was strong. None of that rises to the level where you can find that there is a violation in this case, Your Honor. And so I would ask that she be found not responsible for the violation as alleged, and that this violation be dismissed. Thank you.
Very well. All right. Any rebuttal, Mr. Vander Colt?
No, Your Honor.
All right, well, I have heard the testimony in this case, and really there aren't any physical exhibits entered into evidence. As counsel has indicated, this is a case to be decided purely on the testimony of the witnesses. The standard that I have to find by here, because there is jeopardy of placing Ms. Jackson in the Kent County Jail in contempt of court, is beyond a reasonable doubt that the violation occurred as claimed by petitioner. And I simply cannot find beyond a reasonable doubt that a violation occurred in this matter. There is conflicting testimony. The conflicting testimony is that of Nasir Pettis, who did testify that he went alone to serve this protective order. It is clear that the petitioner did not want to be served a protective order, and that there was some conflict, or refusal to receive it on the other end. She claims that Ms. Jackson rode along with Mr. Pettis. However, there are significant holes in that testimony. They begin with a failure to ID the type of car. The complaint says a Cadillac XT4, however, or XT5, blue Cadillac XT5. That was inconsistent with Mr. Pettis's testimony as to the vehicle he was driving, a failure to identify Mr. Pettis himself as the male, and unquestionably the person that in both accounts, both the violation and her, Miss Jackson's rendition of event, or Miss Cooley's rendition of events would have come closest to her, because he was trying to hand her or serve her with the papers, and that also diminishes the credibility further. Miss Cooley did testify there was another witness who saw this series of events happen, and anytime anyone gets out of a car and sprays pepper spray, and whether or not that pepper spray connects, and there is a conflict in the middle of the street, one would expect it to be memorable to people who witnessed it, and those people to be able to tell exactly what happened, and that simply did not occur here. There was no other witness produced, in the video that might have backed up that account apparently was not functioning during that time. So all of those question marks add up to, in the court's mind anyways, reasonable doubt that the violation occurred as claimed in the violation report. So at this time, I'll dismiss the allegation of the violation. However, I do note the personal protective order here remains in place and will remain in place until at least sometime next year. And I would caution, Ms. Jackson to very carefully observe the requirements of that personal protective order, as it will remain in place. My ruling today does nothing to terminate or end the personal protective order. It just says there wasn't a violation as claimed by Miss Cooley in this instance. Anything else for the record at this time? Mr. Vander Colt?
No, Your Honor. Thank you.
Mr. Hebert?
Ms. Jackson, please, I have something I'd like to state, if I may.
Why don't you talk to Mr. Hebert quickly about it and see if it's something that would be appropriate for the record or not.
Okay.
Thank you, Your Honor.
If we could place them in a breakout room, Lisa.
Miss Jackson is concerned for her own safety in this case, given the circumstances of everything that's been going on. She
Well,
asked,
I must have granted a PPO to her as well if it was being served, right?
so that's what she wanted to ask about, is if it's mutual, or if not, if she has if she can file a PPO against Miss Cooley, to protect herself.
Well, there's no such thing as a mutual restraining order in Michigan. However, and what was being served on this alleged violation back on April 1st of 24 was not a PPO?
I think it was
Maybe an objection or something?
Probably a motion to
Objection to
dismiss
her
the PPO.
yes.
Okay. All right. Well, she is free to file for her own PPO if she feels like she has 2 or more incidents of harassment to support that. She should document it and file it with the PPO office here at the courthouse.
Thank you. And I believe Miss Jackson has previously filed one, and said that she was told because there already is one protecting Miss Cooley, it can't be granted. I
Well,
don't.
yeah, and I mean, the truth of the matter is you can't say this PPO is reciprocal, and that I can't say based on Miss Cooley having a PPO and the conflict involving the PPO, there is a grounds for another PPO. However, and the existence of a PPO, the service of a PPO by a process server or papers coming in the mail or things related to a PPO cannot be a basis for another PPO. However, and I also don't grant PPOs based on police reports, CPS reports, things like that. If people are following the legal, procedures and you're getting contacted by other agencies, typically I don't grant a PPO. However, if there is in-person contact that is harassing or threatening, then I can grant a separate PPO, and I just evaluate those separately at the time they're filed.
Thank you, Your Honor.
All right, thank you all, and thank you all for your decorum during the hearing. With that, we are concluded.
Thank you, Your Honor.